everyone, and thank you so much for joining us today for our presentation on the EB-5 Green Card. This webinar is part of a series. We try to do at least one webinar a week, and these do run the full spectrum of U.S. immigration law, whether that's family immigration, temporary visas like student visas, visitor visas, etc., or business immigration, which is the category of the EB-5. Our firm does focus on business immigration, but as I just mentioned, we do handle the full spectrum of U.S. immigration law. So please don't hesitate to reach out if you have any questions at all about U.S. immigration. My name is Dustin Saldarriaga, and I am a senior associate with Scott Legal PC here in New York City. It is a pleasure to be with you all this morning. As I mentioned, the focus is going to be on the EB-5 Green Card, which is an investor green card. As we will talk about, it does require a significant investment and the creation of jobs. It is a wonderful option for those who are not citizens of an E2 treaty country who want an option to come to the U.S. to build a business that's going to employ at least 10 U.S. workers. Before we get started, though, I did want to touch on a few things. If you do have a question during this presentation, do send it in through either the Q&A function or the chat function on Zoom. I will be monitoring questions. I'll probably save those for the end of the presentation, but I do plan to get to all questions, so don't hesitate to send those in. And after this presentation, you will get a copy of the PowerPoint presentation that you see on your screen. You will get a link where you can sign up for those future webinars that I mentioned, as well as a link to our YouTube channel. So we do post all of our recorded webinars on YouTube. These are full-length, hour-long webinars. Again, they do run the full spectrum of U.S. immigration. Please do check those out. On our YouTube channel, we also do have shorter videos on a range of immigration topics. So we do hope those are helpful to you. All right, without further ado, let's go ahead and dive in talking about the EB-5 Green Card. So the EB-5, as I mentioned, is a green card. So it does permit permanent residency in the United States that can lead to citizenship if you do want to naturalize. That is in contrast to a temporary visa. So a student visa, a visitor visa, an E2 visa, these are all temporary visas, and you need to show the government that you plan to leave at the end of those visas. The EB-5, in contrast, is, as I mentioned, a permanent residency immigrant visa or green card. So that does allow you to stay in the United States permanently. It is the immigrant visa, the investor green card option in the United States. So if you are looking to get a green card by simply investing money, this is going to be the green card option you're looking at. Now, there are two main pathways to get an EB-5 green card. Those two pathways are the regional center option or the direct investment option. So let's talk about each of those. The regional center option is going to be the passive option. It is the option if you simply have an investment amount that you want to invest, not actively manage, and you want to simply wait for the green card to come through. The direct investment option is if you actually want to manage a business. So let's talk about each of those in turn. So as I mentioned, regional center, it is a passive investment. It does generally have high administrative fees. So for example, oftentimes a regional center administrator will charge somewhere in the vicinity of about $50,000 administrative fees for that. And where are those fees going? So a regional center is usually a significant project, a large project. Could be building a shopping center, could be building a mall or a train station, building a resort. So these are projects that require tens, if not hundreds of millions of dollars. And so a single regional center project can support dozens of EB-5 investors. So each EB-5 investor will invest the required amount, typically $800,000, into that larger regional center project. So again, a resort, a mall, a train station. They will all invest into the project. They will be passive investors. not making active decisions on the project. And then after the required period of time passes and the jobs have been created, they will essentially qualify for the green card and will get the green card through the regional center. So that's where those administrative fees are going. So the regional center will pay for administrators, will pay for lawyers, overseeing the project. And again, that tends to run about $50,000 per investor. That administrative fee does not count toward your required investment amount. So that is very important. So if you are, we'll talk a bit more about this, but if the required investment amount is $800,000, say, the administrative fee does not count toward that. You do, however, need to prove where you got the money that you are using to pay that administrative fee. So we'll also talk about that a bit later. So there is risk to regional center projects. Again, you're not in control of them, so they are being managed by someone else. So it is very important that you go with a reputable regional center. You can do your research. There is information that you can look at to gauge whether a regional center is reputable, if it has a good history, if it has any history or not. The simple fact that a regional center is approved by USCIS does not mean that it is necessarily a good option. USCIS makes that clear in their documentation that when they approve a regional center, it essentially allows the regional center to be a regional center, acknowledged by the government, but it is not the government vetting that regional center in terms of whether you're going to get your investment back, whether the regional center is going to fail. That does happen. So it is important that you do your independent research and find a good regional center. One of the big benefits of a regional center is that indirect jobs are counted. So let's take an example here. If the regional center project is a resort, then direct jobs would be W-2 employees that are employed by the resort. So let's say the resort employs a manager. The resort might employ front desk staff. Those would be direct employees of the regional center. Indirect jobs would be, for example, if at the resort there is a store that opens. Let's say there's a convenience store that opens on the property that's run by, let's say, Stop and Shop, a large grocery chain. Those jobs that are created by the creation of the resort would also count. So those are not jobs. Those are not jobs that are directly employed by the resort, but they are jobs that are created because the resort now exists. Similarly, construction workers, for example, who may be independent contractors, those jobs can also count in the regional center context. So construction workers might not be directly employed by the resort, but those jobs are created by the existence of the resort. So that's a huge benefit. The regional center will typically do an economic report that explains how these jobs should be attributed to the regional center. That's not typically something that the EB-5 investor, you would be doing. That's done by the regional center. Regional centers are usually in targeted employment areas. This is a big deal. So what that means is that they require a lower investment amount. So we'll talk a bit more about this, but there are really two different dollar amounts, two different investment amounts that are required for an EB-5 green card. The lower amount that I'm talking about is if the EB-5 business is in an area of high unemployment or a rural area. There are a couple other categories, including infrastructure projects, for example, that might also qualify for a lower investment amount. But by and large, TEAs, projects that are in targeted employment areas, these are because it's high unemployment or rural areas. Regional centers almost always exist in a TEA, a targeted employment area, meaning that you can invest the lower amount, the $800,000 amount. If the EB-5 project is not in a targeted employment area, then it generally requires an investment amount of $1,050,000. So this is a benefit of the regional center, is that almost always you're going to qualify for that lower investment amount. Direct investment projects can also be in TEAs. So no prohibition on that at all. You can still have the lower investment amount. It's just that you need to make sure that your business is located in a TEA. And finally, regional centers can support more than one EB-5 investor. So as I mentioned, a regional center can be a large resort, for example. You can have dozens of EB-5 investors supported by a single regional center project. That is not the case with a direct investment project. A direct investment project can only support one EB-5 investor. So let's talk about the direct investment option. The example I like to use is a restaurant. Let's say that you have $800,000 and you want to start a business located in an area with high unemployment. You would start your restaurant, you would invest your $800,000 into the business and create 10 jobs from that investment. That would be a direct investment. So the restaurant is not a regional center. It is simply a business that you want to actively run as the EB-5 investor. Again, a direct investment business can only support one EB-5 investor. So let's say that you and your friend want to both apply for an EB-5 visa. You could not do it based on a restaurant that you are starting. You would both need to go with a regional center option if you wanted more than one EB-5 investor based on a single business. Now, of course, as you can see from my example, you would have, as the EB-5 investor, a lot more control over the business than you would in the regional center context. So you would be in charge of the restaurant. You would be doing hiring. You would be managing the business. In the regional center context, you really don't have any control. If it's a shopping center or a resort, for example, you're not deciding, about the design of the business, marketing decisions, management decisions. You have no role in that, really. You're typically a limited partner on that business with really no active role. Whereas direct investment, you have a very direct and a very active role. You're making the decisions about how that business operates. As part of that, there is potential for higher investment return on a direct investment option. So if it's your business, if it's your restaurant, the sky really is the limit. If it's a restaurant that does very well, then you could profit from it significantly if the business does well. Of course, you also carry the risk that it not do well. With the regional center context, typically the return is minimal. You're not usually going to see a high return from a regional center option, whereas if you are running the business in the direct investment option, you can see a very high return depending on the performance of the business. Only direct jobs are counted in the direct investment context. So if you're running that restaurant, it is only going to be people that are directly employed by the business. So we're talking W-2 employees of the business. Let's say that it's a very popular business and you buy or a neighbor, a business opens right next to yours, or you have construction workers doing work on expanding the space. Those jobs generally are not going to count. You need to only count direct jobs in the direct investment context. A big benefit of the direct investment option is the stability of the existence of the program. Now, full disclosure, this is not really relevant for the next couple years through 2027 because of Congress reauthorizing the program, the regional center program, and basically making it a bit more robust than it was before. But to give a brief history on the program, the regional center option is a quote unquote pilot program. So even though it was started in the early 1990s, when it is renewed, it is always renewed as a pilot. So it is temporary. It can, and it sometimes does expire, the regional center option. This happened, I believe it was in 2021, 2022, when it was paused for about 9 months. So people who applied for an EB-5 through the regional center option back in 2020, 2021, 2022 saw the program pause for 9 months. So USCIS was basically doing nothing on these regional center applications for 9 months. That didn't affect direct investment projects because direct investment projects are not pilot. They were not implemented by Congress as a pilot program. Direct investment is the EB-5 program, is the heart of the EB-5 program. So direct investment projects should continue to be viable over the years, even if the regional center project expires. We'll talk a bit more about that in a later slide. So the direct investment option, we'll also talk about this final point. Funds already invested can count toward the investment if they are funds that were held by the EB-5 investor personally, and if they were invested before the jobs were created into the business. So we'll talk a bit more about that later. So snapshot of the big EB-5 requirements. First, you need to make the required investment amount. Second, that investment amount needs to lead to the creation of at least 10 full-time jobs for US workers. And that timing is really critical. So you need to make the investment and then the jobs need to be created. They need to flow, the jobs need to flow from the investment. And then you have your EB-5 filing. The EB-5 filing is really three big stages. First is the I-526 form, which is establishing your eligibility for the EB-5 green card. Once that I-526 is approved, the government will consider your I-45 or DS-260, which is the actual green card application. And then once that is approved, you get a conditional green card, which is good for 2 years. At the end of that 2-year period, you do need to apply to remove the conditions from that conditional green card, and that's done by filing the I-829. Once the I-829 is approved, the conditions are removed, you are a permanent resident. So that's the end of the process, unless you want to become a citizen, and then you could naturalize. But for the purposes of the green card, it is 3 steps. I-526, then the green card application, I-485 or DS-260, then the I-829 to remove the conditions. So we've talked a bit about the requirements. Let's get into a few more details. So again, the investment is either 800,000 or 1,050,000. That depends on whether the business exists in a targeted employment area. Again, that's an area of high unemployment or a rural area. You see on your screen this term, new commercial enterprise. That is what the immigration law calls the EB-5 business. So when you create an EB-5 business, that is the NCE, the new commercial enterprise. And the NCE is what needs to create those jobs for US workers. So they would be W-2 employees of the NCE. Which investment can be included? Investment can be made over time. This gets a bit complicated. So if this applies to you, do schedule a consultation. We can talk about this in more detail. So to make sure you're staying aligned with the statutory requirements and the regulatory requirements. The investment, you see investment versus retained earnings. So the funds that can count toward your investment need to be your personal funds. Okay, so they first need to pass through your personal bank account. If you have a business that's already active, so let's say you're an E2 visa holder. Let's say you have a very successful restaurant. You've been running it on an E2 visa, and let's say it has $1 million in retained earnings, and you want to use those funds for the EB-5 green card. You need to first distribute those funds to yourself. You need to pay taxes on those funds, and then you would reinvest those funds into the business, and those funds would then lead to the creation of 10 jobs. It is critical that you distribute those funds first before trying to count them as EB-5 funds. Because again, you need to first hold the funds as your personal funds in order for them to count as your EB-5 investment. The timing, of course, is also important. So the jobs need to be created after you have made that personal investment into the business. This is also relevant if you're receiving the funds as a gift, say. So let's say that your very kind brother is gifting you $1 million for the EB-5 green card, and your brother wants to just transfer the funds right into the EB-5 business. Don't do that. Make sure that the funds first go through your personal account and then you transfer the funds into the EB-5 business. Again, the government wants to see that those funds first flow through your personal account before they go into the new commercial enterprise. Now, I mentioned the E2 visa, and this is because the E2 visa is also a visa that's focused on business. It's focused on giving the visa holder the ability to build a business in the US. So the EB-5 is a common green card option if an E2 visa holder decides, you know what, I want to stay in the US permanently and I may want to be a US citizen. Well, then if someone comes to us and says that I'm on an E2, I want to stay in the US permanently, we are likely going to seriously consider the EB-5. Another good option is the EB-2 National Interest Waiver. We have a separate presentation on that option, so do check that out if it interests you. But the EB-5 really is, in general, a great option for an E2 visa holder to consider. That being said, the E2 and the EB-5 have very different requirements. The EB-5 tends to be a much more difficult application to prepare just because of the documentary requirements that apply to the EB-5 versus the E2. In particular, the EB-5, the USCIS wants to see every single dollar that goes into the new commercial enterprise. And they're going to make sure that every single dollar flowed from the source to your personal account and then from your personal account into the new commercial enterprise, into the EB-5 business. And so you really do need to keep a very thorough, detailed documentation showing the flow and the source of those funds. So I'm talking bank account statements, if you earned from work, the W-2 forms or the equivalent in your home country. If it was a gift, where that person got the money from. If it was inheritance, if it was selling an apartment, you want documentation proving that, because the government is not going to take you at your word alone when it comes to this. They are going to want to see documentation showing that the funds, in fact, came from exactly where you say they came from. The other thing that you need to be very careful of is equity investment. So let's say that, and we'll talk a bit more about this later, but let's say that you are buying a business that already exists. It is absolutely critical that your invested funds not go to the seller's bank account. And that's because your funds, again, need to lead to the creation of jobs. So if you're buying a business for $1 million and you transfer that money to the person selling the business, those funds are no longer in the business. They're in the seller's bank account. The government cares a lot about this. So make sure that if you're doing that, you are investing an additional $800,000 or $1,050,000 into the business that will create the jobs. Or if the seller continues to be an owner of the business, it's possible for those funds to remain in the new commercial enterprise business account. That is your commitment to the business to purchase the shares, and then those funds can be used for job creation. This is a nuanced topic, so do schedule a consultation if you have questions about that. So I've touched on these points already, but let's go over them again. Critical for the EB-5 is the creation of at least 10 full-time jobs. Okay, and those jobs, again, if it's a regional center, there's a little more flexibility in terms of what counts as a job, an EB-5 job. For a direct investment project, those need to be direct employees, and they do need to be full-time, at least 35 hours a week. And that's going to be either U.S. citizens or green card holders. So that is critical. In fact, the EB-5 green card is called a job creation green card. So job creation really is at the heart of the EB-5 requirements. Again, there needs to be a link between the investment and job creation. So the investment needs to happen, and those funds need to lead to the creation of those 10 jobs. So let's say you have an E2 business, it already has 10 employees, and then you invest the $1 million. You need to create 10 more jobs. So the jobs that exist before you make that investment are not going to count toward the 10 full-time job requirement. So how do you show this job creation? Now, as I mentioned before, and as you can see on your screen, the three big steps are the I-526, the green card application, which is the I-485 or the DS-260 if you're applying at a consulate, and then the I-829 to remove the conditions from the green card. You do not need to you do not need to have created the jobs before the I-526 is filed. Really, you need to have created the jobs by the end of the conditional permanent resident period, which is 2 years after your I-485 is approved or your DS-260 is approved and you receive the immigrant visa. So you do have quite a bit of time to create those 10 jobs. So how do you convince the government you're going to create those jobs then? If you're filing your I-526, you're not going to create the jobs for, say, 4 or 5 years. You need a detailed business plan. So a business plan can be a critical part of the EB-5 application. It would be filed with the I-526. And then, of course, you do want to, as soon as you can, get that hiring started so that by the time you file your I-829 to remove the conditions, you can show that you have W-2s, you have payroll records, you can show bank account statements from the business, showing funds going to your workers, showing the government that clearly you now have those 10 positions filled. And that's related to this final point under job creation, documenting full-time positions and qualified workers. So when you do submit that documentation, it will be W-2 forms, which are the tax forms for employees. It'll be I-9s showing that you have actually completed the documentation to hire and employ these workers, showing their status and their work authorization in the United States. We would also typically include payroll records and bank statements showing the movement of funds to employees. Great. So I mentioned before that the regional center program did stall. It was paused for at least 9 months back in 2021, 2022. And as a result of that, Congress did pass the EB-5 Reform and Integrity Act, called the RIA for short. There were a number of changes that came about as a result of this law, both good and bad changes. One of the changes is the investment amount increase, the required investment amount. So it increased to $1,050,000 for those businesses that are not in targeted employment areas, again, high unemployment or rural areas. For businesses that are in TEAs, the investment amount increased from 500,000 to 800,000. So the overall investment amount is higher as a result of the RIA. Now, the positive change is that the Regional Center Program is reauthorized until September 30th, 2027. So presumably there are no concerns about the program ending before that date. And also, the law does say that if you file a regional center petition before September 30th, 2026, the government does assure you that the application will be decided. So in other words, if the program's not reauthorized, it's not like your application is not going to be decided. Your application will be decided if you file before that September 30th, 2026 date. The rules that apply to TEAs did change. The US government now determines what a TEA is. In the past, it could be a state entity, for example, to decide what areas are high unemployment or rural. Now the federal government makes that decision. One very positive change, in my opinion, is there are EB-5 green cards set aside for certain types of projects. So 20% of the EB-5 green cards are set aside for rural areas, 10% for high unemployment areas, and 2% for infrastructure projects. And this is great because if you're from a country with a significant backlog in EB-5 green cards, such as China or India. By applying in one of these set-aside categories, you actually can get a green card much faster. And if you're in the US, you can concurrently file an I-45, which leads us to our next point. The RIA, passed in 2022, does allow concurrent filing. So what does that mean? That means that you can file your I-526, which is the first step, at the same time that you file your I-45, which is your green card application. This is actually a huge benefit because what this means is those who are inside the US, so you need to be inside the US to file an I-485. But if you file an I-485 at the same time, you can file an application for travel authorization and an application for work authorization. So those travel and work permits do take about 6 to 9 months typically. But once you've waited that period of time, you get travel authorization and work authorization. So you can work without restriction. You can generally travel without restriction. Again, that is if you're in the US and if you file those applications along with the I-45 and the I-526. So a big benefit. So now if you're inside the US and and if green cards are available for your category, so again, those set-asides play a big role there. Then you can, within 6 to 9 months, get travel and work authorization, which is a big deal for those who are inside the US, as opposed to waiting outside the US for years and years for the application to be approved. Another change from the RIA is that the government does require that you document where you got the money to pay for the administrative fees. So that's in addition to the EB-5 investment amount of $800,000 or $1,050,000. You'd also need to prove where you got the money to pay the administrative fees. The government also clarified loans and gifts are acceptable. There are constraints on this for gifts, for example, the funds and loans, the funds do need to travel through the personal account of the applicant first before going into the new commercial enterprise. You also need to document exactly where the funds came from, even if they are a gift or a loan. So do be aware of that. But gifts and loans, generally speaking, are acceptable if the funds were lawfully acquired and legitimate, and you can document where they came from. Also, the law did give applicants some flexibility if the regional center fails or closes. So this is a positive development as well and gives some protection to the applicant. We're not going to go into much detail, but do schedule a consultation if you think that's relevant to you. So what else should we consider when thinking about an EB-5? So the investment's really, excuse me, really key. Again, you do need to make sure that those funds are traveling through your personal account and that you can document exactly where they came from. You do have some time to actually spend the funds. So our general recommendation is that, excuse me, by the time you file the I-526, the funds actually have been transferred into the new commercial enterprise. So they need to be in the business's bank account, not sitting in your personal account. So by the time you file the I-526, have those funds sitting in the business bank account. In terms of spending the funds, you do have more time to do that. So that is a positive a benefit of the EB-5. You don't need to have spent all the money before you file the I-526, and you certainly don't need to have created the 10 jobs before you file the I-526. If you are using a loan or a gift, make sure you've documented the entire process, including where the person loaning or gifting you the funds got the money. They need to provide that documentation as part of the application. If you're using cryptocurrency, you want to make sure that you can document all of it. So if the cryptocurrency trail doesn't have documentation, that is going to be a problem. However, if you're using a reputable company for the crypto, you have documented well, your account and the movement of the funds. Crypto can work. You just need to make sure you can document it. and are using a reputable company along the way. Considerations for purchasing a business. I did talk about this before. If you are transferring funds to the seller and to the seller's account, meaning that those funds are not going to be retained by the EB-5 company, that's going to be a problem for the EB-5. So any funds that you want to count toward the EB-5 investment actually need to be in the business's account and ultimately spent for the creation of those 10 jobs. So if you're buying a business, make sure to invest an additional amount that will be held by the new commercial enterprise. Or again, if you're buying a percentage of the shares and the current owner is staying on as an owner, then you may be able to transfer those funds into the business account, and then they could be deployed from there toward the creation of jobs. How much do you need to own of the EB-5 company? This is a common question. And fortunately, your ownership share can be minimal. As long as it's above zero, you do need to own something. You need to have some management ownership role. Even in the regional center context, you're going to be a limited partner typically. But you don't need to own a significant percentage. So in the E2 context, you need to own at least 50% of the company. That's not the case here. Here, your ownership can be 1%, 2%. That's fine. Be very careful. This next point, guaranteed return of investment. The government, if it sees any suggestion that you are guaranteed to get your money back from the EB-5 investment, they will likely deny the application because they want to see that this is an at-risk investment, that there is the possibility that you'll lose your EB-5 investment amount. So, if there's any language that suggests that there is no risk, that you can always get back your investment, that's likely to lead to denial. So closely review any agreements you have, any operating agreements or loan agreements, whatever it is. All of the documentation should show that this is an at-risk investment and that there is a real possibility that you will lose your investment. So I know people don't like hearing that, but that is what the government is going to require. So don't go down this path, and wait years to get the EB-5 green card only to find out that that provision giving you security is going to result in your application being denied. Moving from an E2 to an EB-5. What investment can count? So in general, any investment that is your personal funds that have been distributed to you, that you've paid taxes on, and that you hold in your personal account, generally any funds that have gone through that will count. What does not count are retained earnings. So again, if you have an E2 company that's done well, it has retained earnings, you need to first distribute those funds to yourself as the owner, pay taxes on them, reinvest them, and then those funds can count as the EB-5 investment. Job creation, the timing is important. So the jobs need to follow from your investment. So do make sure that investment happens, again, of your personal funds, and then those jobs are created after that. And again, buying a business, I've mentioned already, you need to be careful that the funds are actually going into the new commercial enterprise rather than to the seller directly. So here we have an example. I'm not going to spend too much time on this example, but you can see that what we're getting at with this example is some of the ideas we shared before. So let's just quickly go through it. Helen got an E2 visa in 2015 when she purchased shares of a business for $300,000. So the first question is going to be, when she purchased those shares, did those funds go to the seller directly, or did those funds go into the business itself, which could be the case if the seller remained an owner. If the former, if they went to the seller, those $300,000 are not going to count. At that time, the business had 5 full-time employees when she purchased the shares. So again, those jobs are not going to count because the jobs need to happen after she made the investment. She paid lawyers $40,000 in legal fees. That investment is also not going to count because those funds are not going into the business for the creation of jobs. Those funds are going to lawyers. At the end of 2019, so that's 4 years later, she invested another $500,000, which she received as a gift. The person who gave the gift got the money from the sale of property they inherited 15 years ago. Instead of giving the money to Helen, they deposited the money directly to Helen's business bank account. That's a problem. So those funds are not going to count because they never pass through Helen's personal account. All right. They first need to be held by the EB-5 investor personally and then put into the EB-5 business. So right now, as of now, she has not invested anything into the business for purposes of the EB-5 investment. When the money was invested, she had 10 full-time employees working at the company. She hired 5 since she bought the company. So again, those are not going to count because she has not invested anything so far. And the jobs that will count are ones that follow from the EB-5 investment. At the end of 2019, she paid herself a bonus of $100,000 after the company made $1 million. All right, so if she then reinvested that $100,000 into the business, then that would count as an EB-5 investment. So we are far below the $800,000 that she needs to invest into the business, or $1,050,000 if it's not in a high unemployment or rural area. On January 1st, 2020, she applied for an EB-5 green card, showing a total of 1.8 million invested. She also included information showing that she had created 10 full-time jobs. So again, her investment amount is not 1.8 million for the purposes of the EB-5. So she has quite a bit more to invest, at least 700,000 more. Since, even assuming it's a TEA, a business in a targeted employment area, she has only invested that bonus of $100,000 after tax. And I don't know how many jobs have been created after that investment. She plans to hire another 3 or 4 employees going forward, but is not committed to this. So she needs to hire at least 10 people, 10 full-time equivalent US workers after she's completed the investment. Her business is located in an area where the unemployment rate is 7%. So this is good news. So she is likely in a TEA, so would qualify for that lower investment amount. But unfortunately, Helen does still have a lot of work to do. So she needs to invest at least $700,000 more and then create 10 jobs from that additional investment amount. So as you can see, it's not automatic. Just having a successful E2 business does not lead to an EB-5 green card. There are a number of aspects along the way. So it is worth talking with an immigration lawyer about this. This is considered to be one of the more complex areas of business immigration law. A few final considerations to be aware of, and if there are any questions, please do feel free to send those in. So the first is timing considerations. So the important thing to know here is that the EB-5 is not a fast option. Right now, let's actually just look at actual information published by the government. So USCIS processing times, you can look this up as well if you Google USCIS processing times. The I-526, which if you remember is the first step of the EB-5 application process, the government is estimating that the I-526 alone is taking 63.5 months, so over 5 years for the government to decide. We think that's unreasonably long. We actually do have an active and a very successful litigation practice where we sue the government saying that this is not reasonable and the government needs to do its job faster than this. And we've had quite a bit of success with that. Of course, that doesn't promise the same in the future, but we have had success with those lawsuits. But if you are just going by what the government says, that I-526 is likely to take about 5 years. The I-829, which if you remember is the removal of conditions, that is taking, the government estimates, 45 months, so almost 4 years. So as you can see, the EB-5 is not a fast process, and unfortunately, the government has come to see lawsuits getting sued as the typical way to expedite a case, which is very unfortunate because suing the government is time consuming, it is expensive, but if you're in this situation and you do need a decision faster, then suing the government, unfortunately, really is the option that's available to you. That being said, if you are using one of these carve-out categories, so rural, high unemployment, or infrastructure, we have seen that the government will sometimes issue a decision in a quite quick time frame. So it could be within a year or 2 years. So just because the government is publishing 5 years does not mean that that's actually going to be the time frame that applies to you. One other thing I did want to quickly explain is the visa bulletin. So why are those carve out categories important? If we look at the visa bulletin, and you can find the visa bulletin by Googling visa bulletin and clicking the link. The visa bulletin is issued by the US Department of State every month. And basically what it is every year the government makes a certain number of green cards available. And there are certain categories of people applying for green cards. So the EB-5 is employment-based, fifth preference category. If you are applying as a leader in your field internationally, then you may be able to apply for EB-1, which is the first preference category. So there are a certain number of green cards for EB-1s, there are a certain number for EB-2s, EB-3s, EB-4s, EB-5s. That's why this visa bulletin is issued, is because every month a certain number of those green cards are issued. So it's updated every month to say how many are left basically this year. And if there's a line, if there are more people waiting for the green cards than are available, then there are green cards available, then that backlog is created. So looking specifically at the EB-5 category, if you are from, meaning if you were born in China and you have applied for an EB-5 green card and you are not applying in an area of high unemployment, a rural area, or an infrastructure project, you are looking at about a 9-year wait at least before your green card's available. So that I'm not talking about the delays at USCIS that we were talking about a minute ago, where the delay is 5 years. I'm talking about the green card even being available to you. It's going to be at least 9 years before that green card's available to you. If you apply in an area that is not high unemployment, not a rural area, and not an infrastructure project. If you do apply in a rural area, an area of high unemployment, or an infrastructure project, then green cards are available now. That category is current. What that means for you is, let's take an example. If you're in the US on a student visa and you're from China, born in China, you have a Chinese passport, and you want an EB-5 green card, if you are applying in a rural area, high unemployment, or an infrastructure project, you can immediately file the I-485 with the I-526, which means you can also apply for work authorization and travel authorization along with that I-485. So in 6 months to 9 months, you can have an unrestricted work permit and an unrestricted travel permit. Again, if you're in the US and if you're applying in a targeted employment area, high unemployment, or a rural area, or an infrastructure project. So that's a huge benefit to those who are from China or India. India also has a backlog. And you're inside the US, you can file concurrently if you're going for this TEA, targeted employment area. That's why that is so key. If you're outside the US, this is also relevant because it means that your green card will be available quicker. You don't have to wait 9 years before the green card's available if you apply in a targeted employment area. So that's why these carve-out categories really are helpful. And again, country-specific quotas, that's what I was saying before. In the EB-5 category, it's really only China and India that have backlogs right now. All other countries are current for the time being, but that can change month to month. So do follow that visa bulletin. Travel considerations and visa expiration date. So the thing and dual intent considerations, the next point, these are related. So this does get a little bit complicated. Do schedule a consultation if you have questions. But basically, if you are on a temporary visa, meaning, say, an E2 visa or a student visa, a visitor visa, you want to be very, very careful about filing a green card application because one of the conditions of getting a temporary visa, generally speaking, a temporary visa, um, is that you not have the intention to adjust status in the United States. So you can't say I'm entering on a visitor visa and I'm going to apply for a green card as soon as I come into the US. You're going to be denied entry, or you're going to be denied the visa if you do that, the temporary visa. So what the government does allow is if you do have a temporary visa that you're relying on, you can't have the intention to apply for a green card when you're entering the US or when you're applying for the visa. It is okay if you change your mind. It is okay if circumstances change and you realize, you know what, I now do want to adjust status, but let's say 3 months have passed since I last entered. That's generally speaking not a problem, but you cannot use a temporary visa to come into the US to then apply for a green card. So you do want to make sure that before you apply for the EB-5, meaning when you file the I-526, you want to make sure that your underlying temporary visa, meaning say your E2 or your student visa, is valid, that you're not going to need to renew that visa right after you file that green card application. You also want to make sure that you're ready to explain if you're ever questioned that you're not going to adjust status. So one of the ways you can do that is by choosing consular processing on your EB-5 application. So saying, I'm not going to adjust status in the US, I'm actually going to apply at a consulate, which requires you to leave the US. That can reduce questioning. Now, of course, if your plan is to adjust status, then it is important that you not do that as soon as you come into the US. Also, fundamentally, you should not intend to do that. But if your circumstances change, if your mind changes, it is okay to adjust status after entering on a temporary visa. If circumstances change, your mind changes, and some time has passed since your last entry. Parallel green card strategies. You can apply for more than one green card. So I mentioned before the EB-1. So let's say that you are very successful in your field, you are nationally and internationally renowned, you qualify for an EB-1. You can file an EB-1 and you can file an EB-5. You may do this if you think the EB-1 is risky. The EB-5 is going to take a while, but it's a little less risky if it's clear that your source of funds is fine. We do this for clients. So we recently had a client who applied for an EB-5 and an EB-2 in IW. And the EB-2 in IW, National Interest Waiver, we have a separate presentation on that if you're interested. You can find it on our YouTube channel. You can premium process. You can get a decision on that within 45 days, which is wonderful. So he got an approval on his NIW, but it was a risky NIW. We weren't sure if it was going to be approved. So we filed the EB-5 as well, just to have that running in parallel, just in case the EB-2 was denied. Now, fortunately, it was approved. So for the time being, we're keeping both running at the same time. And planning is key. I think this is especially clear when I was talking about the amount of time it takes to apply for an EB-5 and the dual intent issues. So plan ahead, talk with a lawyer so that you can really map out your long-term plan for getting this EB-5 and maintaining any other temporary visas that you need to maintain. That's really critical. So do reach out with any questions on that. We'd be happy to talk with you over a consultation. So I think that actually answers all of the questions. We do hope to see you on future webinars. Visit our YouTube channel. Reach out if a consultation would be helpful. We are always happy to talk. Until then, stay well, and we hope to see you soon.